If you have been losing sleep over your immigration case, if you have been refreshing your USCIS case status tracking page dozens of times every single day, if your family WhatsApp group has been flooded with terrifying headlines about deportations, visa denials, and impossible new rules, then I need you to stop everything right now and listen very carefully, because today I'm going to share verified, fact-checked official immigration news that could completely change how you feel about your future in America. February 2026 has brought developments that many immigrants never thought they would see, and I am going to walk you through every single one of them with complete honesty, absolute clarity, and information you can actually trust. Welcome back to Global Immigration Updates. My name is Saqib, and as always, my commitment to you is simple. I will never sensationalize your fears. I will never exploit your anxiety for views. I will only bring you immigration news today that has been thoroughly verified against official government sources, and I will always tell you exactly what is real, what is rumor, and what you actually need to do to protect yourself and your family. Now, let me be very clear about something before we dive into these developments. When I use the phrase major wins for immigrants, I am not exaggerating for dramatic effect. I am describing concrete, verifiable policy implementations, processing improvements, and administrative changes that have either already taken effect or are in the final stages of implementation as we enter February 2026. These are not campaign promises. These are not proposed bills sitting in congressional committees. These are actual changes that are affecting real cases right now. And I'm going to explain each one in the kind of detail that actually helps you understand what this means for your specific situation. Let us begin with what I consider to be one of the most significant developments affecting employment-based green card applicants and their families. After years of advocacy, legal challenges, and administrative delays, we are now seeing the practical implementation of expanded work authorization protections for H-4 visa holders and certain dependent visa categories. For families who have been waiting in the green card backlog for 5, 10, sometimes 15 years or more, the ability for both spouses to maintain employment has always been a critical lifeline. The fears that swept through immigrant communities in previous years about potential termination of H-4 EAD programs created enormous anxiety. What we are seeing now in February 2026 is not just the preservation of these programs, but actual streamlining of the renewal process that has reduced processing times significantly compared to what applicants experienced in 2023 and 2024. Now, I want to pause here and address something that has been circulating on social media regarding these work authorization improvements. Some content creators have been claiming that H-4 EAD holders no longer need to file renewals, that authorizations have become automatic and permanent. This is absolutely not accurate. The improvement we are seeing relates to processing efficiency, reduced requests for evidence rates, and better coordination between employment authorization, document renewals, and underlying visa status extensions. You must still file your renewal applications. You must still track your USCIS case status. You must still ensure that you maintain valid status throughout the process. Please do not let viral misinformation cause you to miss critical filing deadlines. The second major development that I want to discuss relates to the green card backlog, particularly for applicants from countries that have historically faced the longest wait times under the per-country limitation system. While the fundamental structure of the per-country caps remains established in statute and requires congressional action to fully reform, what we are seeing in February 2026 is the continued effect of visa bulletin movements that have been more favorable than many analysts predicted. The combination of visa number recapture provisions that were implemented in previous legislation, improved consular processing capacity following the recovery from pandemic-era backlogs, and administrative efficiency improvements at USCIS service centers has resulted in forward movement in several employment-based categories that is providing relief to applicants who have been waiting for years. I want to be extremely careful here because I know how much false hope can hurt when you are dealing with an immigration case that affects every aspect of your life. I am not telling you that the green card backlog has been eliminated. I am not telling you that everyone in the EB2 or EB3 categories from backlogged countries will receive their green cards this year. What I'm telling you is that the trajectory we are seeing in February 2026 represents meaningful progress compared to the stagnation and retrogression fears that dominated conversations in previous years. If you are an employment-based green card applicant, the single most important thing you can do is ensure that your employer's immigration counsel is tracking visa bulletin updates monthly and that your priority date is accurately recorded in your pending adjustment of status application. Now let us talk about family-based immigration, which affects millions of families across the United States. For those of you who are navigating the marriage green card process, there is genuinely positive news regarding processing times at several USCIS field offices. The investment in adjudication staffing, interview scheduling technology, and case management systems that USCIS announced in previous fiscal years is now translating into reduced wait times for adjustment of status interviews in many jurisdictions. This does not mean that every marriage-based case is being approved quickly. Cases that involve complex legal issues, prior immigration violations, fraud indicators, or inadmissibility grounds will still require extended processing and possible referral to specialized units. But for straightforward cases where both spouses have clear documentation, genuine relationships, and no complicating factors, the experience in February 2026 is measurably better than what applicants faced in 2022 and 2023. There is something else I want to address regarding marriage green card applications because I have seen this question appear repeatedly in recent weeks. Some applicants have heard rumors that USCIS has reduced scrutiny on marriage-based cases and that interviews are being waived more frequently. Let me give you the accurate picture. USCIS does have the discretionary authority to waive interviews in certain cases, and the criteria for interview waiver eligibility have been clarified in recent policy guidance. However, this does not mean that USCIS scrutiny has decreased. What it means is that resources are being allocated more strategically. Cases with clear fraud indicators, significant age differences, limited relationship evidence, or other red flags are still receiving thorough review and in-person interviews. If you are filing a marriage green card application, you should absolutely prepare as though you will have an interview. Prepare thorough documentation of your genuine relationship. Do not assume anything about your case based on what someone else experienced. Every case is evaluated individually. The third area where we are seeing meaningful positive developments relates to humanitarian protection categories, specifically temporary protected status and related programs. February 2026 has brought extensions and redaccations for several TPS-covered countries, providing continued protection and work authorization for hundreds of thousands of individuals who would otherwise face impossible choices about their futures. For TPS holders who have been living in legal limbo, uncertain whether their protection would be extended, these official announcements represent genuine relief. The Department of Homeland Security has published Federal Register notices confirming extension periods, re-registration windows, and automatic extension of employment authorization documents for eligible TPS beneficiaries during the re-registration period. Again, I must address misinformation that is circulating. TPS extension does not mean green card eligibility has changed. TPS is temporary protection from removal and provides work authorization, but it does not by itself create a path to permanent residence. Some TPS holders may be eligible for green card applications through other channels such as family-based petitions or employment-based sponsorship, but TPS status alone does not make you eligible for a green card. If you are a TPS holder who wants to explore permanent residence options, you need to consult with a licensed immigration attorney who can evaluate your complete immigration history and identify whether any pathway exists for your specific situation. Let us now discuss what has been happening in the student visa and academic immigration space. For F1 students and STEM OPT participants, February 2026 brings continued stability in the optional practical training program that allows international students to gain work experience in their field of study following graduation. The fears that circulated in previous years about potential OPT termination or dramatic changes to STEM extension eligibility have not materialized into enforceable policy changes. Students who are maintaining valid F1 status, complying with program requirements, and timely filing their OPT applications continue to receive approvals within normal processing timeframes. What I am seeing in current USCIS data and official announcements is actually an improvement in USCIS processing times for Form I-765 OPT applications compared to the severe delays experienced during peak pandemic-affected periods. This is genuinely good news for students who need timely work authorization to begin employment with sponsoring companies that may eventually file H-1B petitions on their behalf. Speaking of H-1B, this is an area where I want to provide very careful analysis because it affects so many viewers of this channel. The H-1B visa program continues to operate under the registration system that was implemented in previous years, and the registration period for fiscal year 2027 will be opening in the coming weeks for prospective H-1B beneficiaries and sponsoring employers. The key developments to be aware of include ongoing implementation of beneficiary-centric selection designed to reduce multiple registrations for the same individual, continued USCIS efforts to identify and prevent fraudulent registrations, and processing improvements for approved registrations moving through the petition phase. I want to be honest with you about the H-1B landscape. The demand for H-1B visas continues to dramatically exceed the statutory cap. The selection process remains a lottery for cap subject positions. Being selected in the lottery does not guarantee approval, and the petition still must demonstrate that the position qualifies as a specialty occupation and that the beneficiary has the required credentials. What February 2026 brings is not a transformation of these fundamental realities, but rather improved integrity in the selection process and better processing efficiency for selected petitions. Now, I want to take a moment to discuss something that does not get enough attention in immigration news coverage, and that is the importance of understanding what has not changed. Immigration law in the United States is established by statute passed by Congress and signed by the President. Major changes to who is eligible for visas, how many green cards are available, and what the requirements are for naturalization require legislative action. This is why I always caution viewers against believing claims that everything has changed overnight based on a single announcement or executive action. Executive actions and agency policy changes can affect how existing law is implemented, what priorities are set for enforcement, and how discretionary decisions are made, but they cannot override statutory requirements. When you see headlines claiming massive changes to immigration, your first question should always be whether this is a change in law, a change in policy, or simply a change in how someone is interpreting or reporting existing practice. As we enter February 2026, the core statutory framework of immigration law remains what it has been. The Immigration and Nationality Act continues to govern visa classifications, admission requirements, grounds of inadmissibility and deportability, and paths to permanent residence and citizenship. What has improved is how that framework is being administered, how efficiently cases are being processed, and how fairly adjudication decisions are being made within the discretionary authority that the law provides to USCIS and other agencies. For everyone watching this video, regardless of what visa category you hold, what petition you have pending, or what your immigration goals are, I want to offer some practical guidance that applies across the board in this current environment. First, monitor your case status regularly through official USCIS channels. The Status of My Case USCIS tool is your authoritative source for where your application stands. Do not rely on processing time estimates from social media. Do not assume your case should move at the same speed as someone else's case. Check your official status and respond promptly to any requests for evidence or notices from USCIS. Second, maintain your underlying status and do not let any component of your immigration situation lapse while relying on assumptions about what might happen in the future. If your visa stamp is expiring, your work authorization is approaching its end date, or your status requires extension, Take action well in advance. Do not wait until the last moment hoping that some policy announcement will change your requirements. Third, keep thorough documentation of everything. Whether you are in a marriage green card process, an employment-based green card case, or any other immigration matter, documents matter enormously. Keep copies of everything you file, everything USCIS sends you, and everything that supports your case. This protects you if anything is lost, if there are questions about your case history, or if you need to demonstrate eligibility for future benefits. Fourth, be extremely careful about immigration advice you receive from non-attorneys. Social media groups, community forums, and well-meaning friends often share information that is incomplete, outdated, or simply wrong. What worked for someone else's case may not apply to yours. What was true under previous policy may have changed. What seems like simple advice may have complex legal implications. If you are making significant decisions about your immigration case, consult with a licensed immigration attorney who can review your specific circumstances. I also want to remind everyone that the information I provide on this channel is general educational information about immigration law and policy. It is not personal legal advice tailored to your individual situation. I do not know the details of your case, your immigration history, your personal circumstances, or the specific legal issues that may affect your eligibility for benefits. Please always verify information through official government sources such as uscis.gov, the Department of State website, and the Federal Register, and consult with qualified legal counsel for guidance on your individual case. As I conclude this update on the major wins for immigrants that February 2026 has brought, I want to leave you with a message that I hope provides genuine reassurance. The immigration system in the United States is complicated, slow, and often frustrating. But it is also a system where millions of people successfully navigate the process every year, receive their green cards, become citizens, and build the lives they dreamed of when they first began their journey. The improvements we are seeing in processing times, the stability in key programs, and the continued operation of paths to legal status represent real, meaningful progress. Do not let fear-based content creators convince you that everything is falling apart. Do not let viral misinformation make you take actions that could harm your case. Stay informed through reliable sources. Stay prepared by maintaining your documentation and status. Stay connected with qualified legal help when you need it. And stay hopeful because the wins we are seeing in February 2026 are real, and more importantly, they are affecting real people, real families, and real futures. If this analysis has been helpful to you, I genuinely encourage you to subscribe to Global Immigration Updates if you have not already. This channel exists to provide you with accurate, verified, trustworthy immigration news that respects your intelligence and your anxiety in equal measure. By subscribing, you ensure that you receive immediate notification when important developments occur, when new USCIS updates are announced, and when you need to take action to protect your case. Please share this video with anyone in your community who may be affected by these developments, or who has been worried about immigration news they have seen elsewhere. Accurate information is one of the most powerful tools we have against the anxiety that immigration uncertainty creates, and you can be part of spreading that accuracy. Finally, leave your questions and your thoughts in the comments below. Tell me what specific immigration topics you want me to research and analyze. Tell me what concerns are weighing on you as you navigate your own immigration journey. I read your comments, I hear your concerns, and I use your questions to guide future content that serves this community. Thank you for trusting Global Immigration Updates with your time and your attention. I will continue bringing you the verified facts, the honest analysis, and the reliable guidance that you deserve. Until next time, stay informed, stay prepared, and take care of yourselves and your families.